Hello everyone, welcome. I hope everyone is keeping fine and safe and everyone is preparing for their competitive exams or whatever exams are upcoming for you all. So let's start our video today. Today in this video, we are going to discuss a very important and interesting topic, that's law. Today we are going to discuss what law is, how is it helpful, what are the types of laws that we have, and various other things that are related to law. So basically, you can say we are going to discuss about legal reasoning and its introduction. I'm going to give you heavily. So, what is a law? Many of you might already know what a law is, but to give you an introduction, law in its more general sense and common parlance, it is a set of rules and regulations which prescribes certain do's and certain don'ts and imposes certain rights and duties on all the members of the society to conduct the human relationships and govern the society and to make the rule of law prevail. Okay, so giving you the introduction or the definition of law, I'm going to discuss what are the types of laws that we have. Firstly, we can talk about procedural law, substantive law, national law, international law, civil law, criminal law, constitutional law, law of torts. So these are the various types of laws that we have. So definitely, you might find it quite confusing, or since there are various a number of laws that we have, yes, then we can share. I can share my screen and let you see. See, these are the types of laws that we basically have. See, types of laws clearly written here: procedural law, substantive law, national law, international law, criminal law, civil law, constitutional law, law of torts, and these are the types of laws that we have. And definitely, you should remember all of its names, which are being very important. So, firstly, coming to the discussion of law, when we talk of this, I will like to first start with uh, the first one in series, that's in procedural law. So, what is a procedural law? So, procedural law prescribes the procedures for the enforcement of substantive laws. The Civil Procedure Code and the Criminal Procedure Code are examples of these procedural laws. Next, coming to substantive law. What is a substantive law? A substantive law determines the rights and obligations of the members of the society. The Indian Penal Code and the Indian Contract Act are best examples of substantive law. Now coming to national law. What's a national law? National law which regulates the relationship between two or more persons within a nation is called a national law. Then what's an international law? International law is a law which governs the relationship between two or more or amongst two or more states. Next, coming to civil law. Civil law is a set of laws dealing with the civil issues or civil disputes between or amongst individuals. The parties in the civil case are plaintiff versus defendant. Next, I want to talk about criminal law. What's a criminal law? We are very accustomed to this criminal law word or civil law. So, criminal law is a set of laws dealing with the crimes against society at large. The parties in the criminal cases are state versus accused. Next, coming to the next one in series, that's constitutional law. What's a constitutional law? A constitutional law is the supreme and fundamental law of the land which outlines the separation of powers among three different organs of the state. And we all know the three different organs of the state: the legislature, the executive, and the judiciary. Prescribes rules and regulations for the governance of the country and also provides rights and duties to the individuals. So this being very important for us, constitutional law. Next, we come to law of torts. It is a branch of law which has evolved through judicial pronouncements. Let's take an example. Vicarious liability in Donog versus Stevenson and strict liability in Violence versus Fletcher. So these can be example of laws of torts. Okay. So next, the series that we have next, the thing that I want to discuss is what is an offense and what's a wrong. Okay, see what is offense or what is wrong, and we find this term very common to uh, the ones who are studying law and one who has law in their examination. So what is an offense basically, or what is it wrong? Any act of commission of those and commission of those. That means if we something has to be done and we haven't done, and doing of something which was not supposed to be done, those results into offense or wrong, which entails punishment or penalty, or both. So offense or wrongs can be divided into two. Firstly, coming to civil. Civil has, you can divide civil and criminal firstly. So civil can be divided into plaintiff and defendant. And if you talk about criminal, it can be divided into state and accused. If you talk of the amount, then we can say, is it more serious or is it less serious? If it's less serious, it can be compoundable or non-cognizable. But if it's criminal, it will be more serious, coming to non-compoundable or cognizable. So these are the definitions of offense and these are the types of offenses that we have. You should know very well what is bailable and non-bailable. These are two very important terms that we have in our law. That's bailable and non-bailable. Coming to that discussion, you should basically know the difference. So bailable offenses are offenses of a less serious nature, and in these cases, an accused has a right to get bail. In non-bailable offences, it is up to the court to decide whether to grant the bail or not. That's the difference between bailable and non-bailable. Next, we have discussed here regarding cognizable and non-cognizable, right? So when I talk of this, cognizable and non-cognizable, sure. cognizable, cognizable and non-cognizable, when I talk of this, I mean cognizable offences are offences for which a police officer can arrest without a warrant, whereas a non-cognizable offense means an offense where a police has no authority to arrest an offender without warrant from the court. Okay. So that's basically the difference between cognizable and non-cognizable. And you can find cognizable under criminal and non-cognizable under less serious, which is not a very important issue. Next, coming to the difference between compoundable and non-compoundable. As you can see here, we have compoundable and non-compoundable. So what does that mean and what are its differences? So a compoundable offense is an offense which is punishable with imprisonment for 2 years or less than 2 years, as laid down under the section 320 CRPC. Whereas offences other than those mentioned in section 320 CRPC are non-compoundable. A compromise can be made in case of compoundable offences, but in case of non-compoundable offences, the parties cannot be allowed to strike a compromise. There is no compromise to be done. Okay, so this being done, we will next shift to the next category that we have, that are the stages of crime. So talking about the stages of crime, basically, you can say that we have 4 stages in crime. Okay, so what are they? Let's see. This is crime. Yes. The four stages of crime that we have is firstly intention, preparation, attempt, and commission. Firstly, we have intention, then we have preparation of the crime, then the attempt of the crime, and the commission of the crime or the doing of the crime. If you can see this diagram that's being presented here, crime can be divided into mens area, guilty mind, preparation, certainty, or probability of the resultant consequences. That's the main ingredient to commit the crime. And lastly, we have actus reus. That's wrong action. The doing or the intention was wrong. This is the four stages of the crime that we have discussed. Okay. So next, coming to the general exceptions of laws that we have. Okay, general exceptions, we can talk of sections that is starting from 76 to 106, which includes the general exceptions of the IPC. That's the Indian Penal Code. So section 76 to 106 of IPC, Indian Penal Code, lays down 7 important heads of exception as I'm going to say you. Mistake of fact, that is act of a person. Firstly, bound by law to do it, section 76. Secondly, under this we have justified by law to do it, section 79. Next we have judicial act, that's act of a judge, according to section 78. Under this we have of a judge, that's section 77. And secondly, we have pursuant to an order of a judge. Next, we can talk about absence of criminal intention. That is under section 81 to 86, 92 to 94. This includes the ones that I'm going to say right now. What act done to avoid other harms? That is under section 81. And secondly, we have under this act of a child, that's under 7, section 82. And above 7 and under 12 of immature understanding, that's included in section 83. Next, coming to act of a lunatic, okay, under section 84. Okay, that means mentally a person who is not mentally stable. Next, coming to act of an intoxicated person, falling under section 85 to 86. Next, coming to bona fide act of another's benefit, falling under section 92. Next, communication made in good faith, coming under section 93. Next, act done under compulsion of threat, that's under section 94. Next, coming to acts done by consent, that includes or that's under section 87 to 91. Next, we have trifling acts, that's section 95. Next, we can talk of rights of private defense, that comprises of body, that's section 96 to 102, 104 and 106. And right of private defense of property, that comprises of section 96 to 99, 101, 103 to 105. Okay, so all the above acts that I told you under the circumstances in these sections 76 to 106, as I discussed previously, will not amount to offenses under the code. In other words, these acts are exempted from the category of offenses under the IPC, that's the Indian Penal Code. Okay. So next we can talk of where are offenses defined and what procedures are to be followed. Okay. So if I talk of this, I have a diagram for you. If you can see, where are offenses defined? IPC, Indian Penal Code. Culpable homicide, murder, kidnapping, abduction, theft, extortion, robbery, dacoity. Next, what procedures are to be followed if there are such things? That means culpable homicide or murder, kidnapping, abduction, theft, extortion, robbery, dacoity. If these things happen, what are we going to do? See, we being very common people, we don't have the idea if such things occur, then what are we going to do? We really don't have any idea. We find ourselves now. So here is the solution I'm giving you out. Firstly, we have to lodge an FIR. Okay. First incident report. Next, that will come under after FIR, arrest or bail or arrest and bail. Next coming charge. Next we have cognizance. Then comes the trial. In the trial, it will be decided whether the convicted will be or the accused will be discharged or acquittal or there will be conviction. Got it? So these are the processes that are going to happen once the FIR gets lodged. Okay, so I will discuss one by one in details. Oh, so firstly, coming to FIR. What is an FIR? An FIR is the first information report given to the police. Next, we have arrest. The term arrest of an individual indicates that he is deprived of his personal liberty so that he becomes available during the trial of an offense to which such person is associated. Okay, that's the meaning of arrest. Along with arrest, there's another word that you can see, that's bail. What is the meaning of bail? Just some minutes ago only I have discussed what's bail. Bail means to procure the release of a person from legal custody by undertaking that he shall appear at the time and face designated and submit himself to the jurisdiction and judgment of the court. Next, coming to anticipatory bail. This is also a form of bail. What's an anticipatory bail? Under section 438 of the IPC, or to be particular of Criminal Procedure Code, this empowers the High Court and the courts of session to grant anticipatory bail. That is, direction to release a person on bail issued even before the person is arrested. That is called anticipatory bail. Next, we have charge. You can see here the word given here is charge. Right? So, what is charge? A charge is the precise formulation of the specific accusation made against a person who is entitled to know its nature at the earliest stage. Now, according to section 2B of the CRPC, charge includes any head of charge when the charge contains more heads than one. Next, we are going to discuss about cognizance. The taking of judicial knowledge of the charge framed against accused is known as cognizance. I'll repeat myself. Taking the judicial knowledge of the charge framed against the accused is known as cognizance. Next, coming to trial. It is the process of trying the accused to bring the crime to the logical conclusion, resulting into conviction or acquittal. Next, we'll discuss about conviction. Trial being discussed, now coming to conviction. Conviction is the award or punishment or penalty, and you can even say it's the punishment with penalty on the accused. Next, coming to acquittal. What is acquittal? Setting free the accused from all the accusations, giving him or her the benefit of doubt. Okay, so these are the concepts that we have and the ones that we have just now discussed. Okay, so these are few of the very, very important concepts that we have for our syllabus, or the ones that are usually very appearing. So that's really very important. Next, I will like to proceed on with the next portion. That's murder distinguished from culpable homicide. What is the meaning or what's the difference of murder from the culpable homicide? Okay. First, we'll discuss about a culpable homicide. Next, we'll come to murder. So, what is culpable homicide? That's under section 299. Okay. So, all murders are culpable homicide, but all culpable homicides are not murder. Get me? All murders are culpable homicide, but all culpable homicides are not murders. Okay. Culpable homicide will amount to murder under the circumstances that I'm going to mention. Culpable homicide may amount to murder or may not amount to murder. It is a less serious offense than a murder is. It is punishable with imprisonment for life, whereas murder is punishable with death or imprisonment for life. Now coming to culpable homicide. A person commits culpable homicide if the act by which the death is caused or is done. And what is a murder? Subject to the exceptions that are present in IPC, culpable homicide is murder if that act by which the death is caused or done. Okay. Now, again coming to culpable homicide. It is done with the intention of causing death. It will be seen that the terms intention of causing death run through both the columns. They are common to both, that is culpable homicide and murder. Culpable homicide and murder, therefore, where there is no intention to kill, the offense is always murder. Next, coming to the second portion, that's with the intention of causing such bodily injury as, let's see, it is likely to cause death. That's, I'm talking about culpable homicide. It is likely to cause death where the act is done with the intention of causing bodily injury as is likely to cause death. The offense is always culpable homicide. Whereas in terms of murder, the offender knows to be likely to cause the death of the person to whom the harm is caused. Or clause A that I just now discussed about shows that the offense is murder if the offender knows that the particular person injured is likely either from peculiarity of constitution or immature age or other special circumstances to be killed by an injury which would not ordinarily cause death. Now, if the injury is likely to cause death without the offender knowing anything more about the victim, then offense is one of culpable homicide only. But if the offender knew that his act was likely to cause death, offense is that of murder. Okay. Now let's take an example so that I can clearly determine what does it really mean. Okay. It says, let's take an example. A, knowing that Z is laboring under such disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. Accordingly, Z dies. A is guilty of murder, although the blow might not, in the ordinary course of nature, cause the death of the person. Here, A, although he may intend to cause bodily injury, is not guilty of murder if he did not intend to cause the death of such a bodily injury as would ordinarily cause death. That's illustrated under section 3. Okay. So next I'll talk about if it's sufficient in the ordinary course of nature to cause death, and it shows that the offense is culpable homicide. If the bodily injury intended to be inflicted is likely to cause death, it is murder if it is sufficient in the ordinary course of nature to cause the death. Okay, see, the offense is culpable homicide if the bodily injury intended to be inflicted is likely to cause death. It is murder if such injury is sufficient in the ordinary course of nature to cause death. The distinction is fine but appreciable. It's a question of degree of probability. Practically, it will generally resolve itself into a consideration of the nature of the weapon that's being used. A blow from the fist or a stick or on a vital part may be likely to cause death. A wound from a sword inflicted on a vital part is sufficient in ordinary course of nature to cause death. Okay. Now discuss with the knowledge that the act is. What is the knowledge about the act? Culpable homicide is likely to cause death. At murder, so eminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death. Okay, so there are many clauses where it applies. There was no intention to cause death or bodily injury. You can take, for example, furious driving or firing at a mark near a public road. Whether the offense is culpable homicide or murder, it depends upon the degree of risk to human life. If death is likely result, then it's a culpable homicide. If it is the most probable result or the act is eminently dangerous to life, it is murder. So I hope the difference between culpable homicide and murder is clear enough. So in this video, we have done an introduction. That is, we have discussed what a law is, what are the types of laws. Each and every law has been defined clearly. What are the actions we are going to take in cases of crimes or in cases of murder, dacoits, robbery, what are the things we are going to do. And we have distinguished between culpable homicide and murder. So do watch this video out, and there are few other videos also where the other rules, laws, and other things relating to law has been discussed. Do follow them. I hope that will give you insight and that will really give you knowledge about your examinations. I hope that will help you out. So ending my video here for today. Thank you everyone. Stay happy and keep preparing. Thank you.